Good morning. It's January 24th in Senate Judiciary. We are handling judge confirmations this morning. We do have one individual who's going to, who I believe has had experience with, excuse me, Judge McLean, who wanted to testify for a few minutes. And then we'll have a response from Judge McLean. And then we'll proceed most likely to the vote. And so we can start with the witness. Good morning. And can you please identify yourself?
Good morning. My name is Winnie Wilkinson, and I live in the St. Albans.
Good morning. So yes, please take it away. I'm planning to give about 5 minutes to you and 5 minutes to the judge to respond, and then we can proceed from there.
Okay. My name is Winnie Wilkinson. I'm a resident of St. Albans, Vermont. I'm also an immigrant. And I have over 35 years experience advocating for civil rights. I'm concerned about the potential appointment of Judge John McLean, particularly regarding with the cases involving marginalized populations. His past decisions on Act 250 legislation that was in 1970 and Section 224 revised on 421 raised concerns of his ability to render impartial decisions. As a representative of the marginalized populations, I am worried that we cannot afford any to adequately have legal representation, which compromise our confidence in Judge McLean's ability to preside over landlord-tenant cases impartially. In his interview, Judge McLean stated his expectations to fulfill his duties on such cases if necessary, which given on the ongoing emergency housing crisis and the legislative reforms, which will fear that his rulings will just make this existing emergency housing crisis worse for the marginalized community. I appreciate the opportunity to express our concerns and fears after Judge John McLean before this community today. January 23rd, 2025.
Thank you. Just a quick confirmation or clarification. Have you appeared in front of Judge McLean or had any sort of professional encounters with him in any way?
I don't know if she heard that.
Ms. Wilkinson, can you hear me?
She was putting her earphones on while her
Ms. Wilkinson?
Yeah, I'm hearing you now. Sorry.
Just wanted to quickly clarify, have you appeared in front of Judge McLean or worked with him in any sort of way? I was unsure.
I sat in on a case that he was the judge concerning a marginalized person who could not afford an attorney. And in the marginalized community, we don't have the confidence that he will rule and taking that part into consideration. And
when was this?
When he was working with the law firm that was representing representing the cities and towns.
Thank you. Judge McLean, you have some time to respond.
Thank you. Well, let me just say that I certainly appreciate generally the concerns that Ms. Wilkinson has expressed about equal justice under the law. And I believe that that is a bedrock principle in my judicial philosophy. I don't know Ms. Wilkinson, I don't recall ever having met her. I understood her comments and concerns to in part relate to landlord tenant issues with which the environmental division does not have jurisdiction over. That's a civil division matter. The environmental division primarily sits on matters of land use regulation, environmental permitting, and appeals from those permits and that permit process. And so, while we have some tangential relationship to housing in the sense that we administer bylaws that relate to housing density, we may sit on appeals from denials of development permits. We typically would not get involved in landlord tenant affairs.
I'm not hearing you clearly, but a point of correction.
Excuse me.
Point of, I'm not hearing you
actually-
clearly. I'm not hearing it clearly, but I just want to make sure that I get the point of correction that I did not say that I met you personally. What I said
We have
was
5
that
minutes for you, and we're providing 5 minutes for the judge to respond. And then the committee will also have 5 minutes of discussion to decide how to move forward. So, thank you. Judge, please proceed.
So I largely stand by my written application, my comments from last week in response to questions, and I just want to assure you that in the context of a concrete case, that I won't hesitate in appropriate circumstances to enforce constitutional rights of all people and to invalidate provisions that I determine to be constitutionally discriminatory. I have been on the bench now for about 6 months, and I have encountered numerous self-represented people. I try to ensure that they fully understand the process that they're engaged in. I will sometimes refer people to the Environmental Division's legal clinic. I believe we are the only division in the state that actually offers a free legal clinic to anyone who wishes to access it. And so I'm not perfect, still learning, but I am making real efforts to better understand the needs of self-represented and disadvantaged persons. And I hope to continue to do that. I think I'll leave it there. I hope that you will confirm my appointment, and I appreciate your time.
Any discussion?
yes, I want to correct
Ms.
part of what
Wilkinson.
the judge was saying.
Ms. Wilkinson, I'm sorry
Hello?
to interrupt you. The way in which these hearings operate, we provide witnesses time to testify, we provide individuals time to respond, and then we proceed to a discussion. We do try to avoid a back and forth between witnesses, as well as back and forth between witnesses and committee. And so I'll ask the committee, is there any discussion or any questions that we wish to ask either of the witnesses? Senator Phillips.
It sounds like one of the witnesses has a clarifying point, but I am curious to hear what it is. So, Ms. Wilkinson, what is the clarifying point that you are hoping for us to hear?
I think she's muted.
Oh, Ms. Wilkinson, you are muted.
Okay, I'm not hearing you clearly. I'm hearing you in and out. So that is why I spoke, because I wasn't, and I really didn't get to see if his mouth was moving to see if he was talking. So I was trying to write my, type my comment. But I want to correct what the judge has said. I did not say that I've met him personally. I sat in a court to support someone else that had a case in front of him. Secondly, we are concerned because he said that he will fill in on cases that concern a landlord tenant, and there is where we are concerned about. I just want to make sure that that is on the record, and that is what I said.
Thank you. Can I ask the judge a follow-up question?
Of course.
Is that true that you would fill in the civil court on landlord tenant?
My understanding is that just very recently, I was assigned as part of the rotation. Last time you asked me whether the environmental division rotates, we don't rotate, but I'm sort of the emergency backup or pinch hitter in the Montpelier Civil Division if Judge Tomasi has an emergency and needs someone to step in. That's the extent of my involvement in the Civil Division.
Do you have a sense of how often that happens?
I do.
Okay, I wasn't sure that you would. That's helpful context. Thank you. And that Montpelier Civil Division is sort of the only spot that you'd be that emergency pinch hitter.
That's my understanding.
Okay. Thank you.
Great. Thank you. So, and also just to clarify, Ms. Wilkinson, I wasn't trying to cut you off or anything. It's just sometimes things get a little chaotic with some witnesses or multiple witnesses talking at the same time while the committee is also talking. So just trying to keep things in a succinct order. So
yeah, I appreciate that. And it was, I wasn't hearing what you were saying because you were cutting off, and I'm trying to get, let it be alert that there's some kind of communication problem so that we all are on the same page, and I'm not hearing everything that you're saying. This is why I was typing. But I honestly appreciate this opportunity to voice our concerns as a civil rights person in the community, as well as to hear the judge's response. And I'm grateful for that.
thank you. And I appreciate your testimony and being willing to come in. Committee, any further discussion, thoughts, questions?
I don't have further discussion or thoughts about this, but I have been reached out to by 2 members of my constituency with concern about a different judge that I'm supposed to meet with this weekend. I haven't had time to follow up in person with them because I've been in the building. And so I just want to put that on the radar of the committee.
Okay. When did they reach out?
One of them reached out yesterday. One of them reached out earlier in the week, but I've been to me, not to the committee.
Okay. Which judge?
I believe Judge Doherty. I may have the last name wrong. Let me take a look. The judge who's also a Burlington City Councilor. Yes, Judge Doherty.
Have they had personal experiences or professional experiences?
I don't know a whole lot. All I got was emails from them saying that they have concerns and would like to speak with me about it. One of them I do know has had a long-standing professional relationship with them.
Okay. Okay, so it's my goal to have any witnesses who are coming to testify in regards to a judge, witnesses who have had some sort of professional interaction or have sat before them or worked with them in some capacity. So if you have witnesses, one who is
I don't know if they want to testify. They just asked me if I would speak to them. It may be enough that we have a conversation. I just have not had time this week to do it because I've been in the building.
okay. In that case, okay, so you said you don't know if they want to testify?
I don't know. I have scheduled time with both of them tomorrow.
Okay.
And I can certainly let you know as soon as I know if
Yeah.
they want to testify.
I'm just trying to think procedurally, if judges are are confirmed in this committee, and I'm looking at you, Senator Bruce, because you've been here the longest, they're sent out of committee, they're on the calendar for 5 days on the Senate floor, is that
Yes,
correct?
and we have, just for context, we've sent people out of committee, and then we have heard additional testimony
Mhm.
beyond that point. So that's an option I believe as well.
Okay. So in that case, I'm prepared unless the committee feels otherwise, to vote on these judges. And in the event that your witnesses want to testify, we can have that happen. If they want to send in written testimony instead, they can also do that, but they are, of course, welcome to testify either in person or on Zoom. And that can be one of the options. Senator Bruce.
So I take the point that there are people out there who have expressed a desire, haven't clearly said if they want to testify. So it seems like a way to disadvantage both sides least, including the judge waiting for confirmation.
Yeah.
If we voted, but if they wanted to testify, we could next week before they come up for a floor vote, we could hear their testimony in committee and then report that on the floor.
Yeah, that's what I was thinking. Okay.
So, given that people have reached out to me with concerns and I don't know what they are, I don't feel like I have an informed position to be able to vote one way or the other. And I know we found ourselves in a position last year or the year before where I know I sat on the floor having gathered more information and feeling like I wanted to vote very differently on the floor than I did in committee. And that was not a position I want to find myself in again. So I don't feel comfortable, but if the rest of the committee does, I'm happy to leave and not vote.
You got the correspondence about this yesterday? About
One of them was yesterday, one of them was a couple of days ago.
Yeah. And I mean, and that, I mean, I get what you're saying. I mean, you're raising the point now about 5 or 10 minutes before we're voting or had been scheduled to vote. Had this been raised last night or earlier this morning, it figured the schedule a little bit. I'm prepared to vote moving forward with the confirmations. If you don't feel comfortable participating, then that's your decision. And in the event that you have constituents who do want to testify, like I mentioned earlier, then we can make that happen within the next week or two. So.
Hazen.
Okay. Thank you. Okay. Senator Matos. Senator Clerk.
Yes.
Will be the one who calls the roll here momentarily. You have the list of names in front of you?
I do, yeah. I just procedurally, I'll start with Senator Norris, work my way down the list, then with you.
That sounds like a great idea. Before that, committee, any further questions? All right, so yeah, please call the roll for each.
So the first one is confirmation of governor's appointment, Bonnie J. Badgwick. Senator Norris.
Yes.
Senator Vihovsky. Senator Baruch.
Yes.
Senator Matos, yes. Senator Hashim.
Yes.
4-0-1. Next one, confirmation of governor's appointment, Dana Mariana D. Sano? Desana? Sorry about that. Senator Norris.
Yes.
Senator Vihovsky. Senator Baruch.
Yes.
Senator Matos, yes. Senator Hashim.
Yes.
Another 4-0-1 vote. Confirmation of governor's appointment, Timothy Charles Doherty Jr. Senator Norris.
Yes.
Senator Vihovsky. Senator Baruch.
Yes.
Senator Matos, yes. Senator Hashim.
Yes.
4-0-1. Confirmation of governor's appointment, Joseph S. McLean. Senator Norris.
Yes.
Senator Vihovsky. Senator Baruch.
Yes.
Senator Matos, yes. Senator Hashim.
Yes.
4-0-1. Governor's confirmation of governor's appointment, Jessica Seaman? Seaman. Senator Norris,
Yes.
Senator Bihovsky, Senator Baruth,
Yes.
Senator Maddows, yes, Senator Hashim.
Yes.
4-0-1. Last one here, confirmation of governor's appointment, Laura C. Roundtree. Senator Norris.
Yes.
Senator Bihovsky, Senator Baruch,
Yes.
Senator Maddows, yes. Senator Hashim,
Yes.
4-0-1.
That be spent, that's it.
Yeah.
Great. So one thing I did want to mention, I failed to mention this during when I said, is there any further discussion? Was doing some thinking. I just wanted to briefly highlight the changes that we made to the judicial nominating board last year. Positive changes, I believe, and I think they were all voted unanimously out of this committee. Which one of the changes was placing Susanna Davis on the director of the Office of Racial Equity on the committee, or the judicial nominating board. And the details and process of the JNB are confidential by statute, that's a whole nother conversation that we can have. But I will just say that having her voice and her perspective on the committee is quite valuable. When we talk about a lot of the issues related to the different demographics that may find themselves in the justice system, whether it's an environmental court, criminal court, or civil court. And I'll leave it at that. So in that case, perfect time.
All right. Sorry, just ran down here from Council Sherry.
Congratulations. And we will have. I'll do two, Bob will do two, and we can figure out the names, who will be what. Oh, yeah. 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 I've spirited every second.
Enjoy the week.
Yeah.
When I go back, you can do
Okay, well, thank you. Great weekend. Thank you.
Thank you.
If you think it's what's that question, let me know.
Okay.
Thank you.
Okay. I guess what you covering right now?
Bail conditions of release.
Oh.
Well, I'm gonna take a minute just to get plugged in and all that. All over.
Softball.
Softball. They say, so
Right.
I don't know where they are.
They were right there.
I know. Just want to catch it for a second. So.
I have to say, I caught a little bit of a grammatical error in my presentation. So I will fix it and then send it to Kayla to post again. But when I was updating the presentation, I didn't delete a line, so. For the professor.
I'm so forgiving. Thank you.
It's gonna look familiar to some of you from last year, but what's so exciting about the legislature is that we passed some laws that are now reflected in this PowerPoint. So, a little joy for Friday, right? Democracy in action.
Before we start, just for the committee, I think this presentation, no pressure, Ben, I think is going to be one of the most important that we hear as it relates to the work that we will be doing related to bail, conditions of release, and that whole area. So, yeah, just wanted to share.
No pressure.
No pressure.
Okay, let me just find the Zoom invite.
Taylor, do you mind sending me this?
I can resend it, yeah.
Yeah, I just. It's Friday. So for the record, Ben Obrowski from the Office of Legislative Counsel. I did do a presentation for this committee on bail and condition release last year. So some of this is recycled content. But as I mentioned before, it's also new given some of, there's also new aspects given the legislation that was passed last year. So I can just start, and then once I get the invite, I'll
Thanks for tuning.
yeah, so we go. There it is. Okay. Go up since the share screen. So yeah. So what? Great. All right, so pretrial release, bail and conditions of release are part of pretrial release. So there are some important terms and definitions to know going into this. The first one is bail itself. Bail is defined in statute as any security, including cash, that's pledged to the court to ensure that the person who's charged with a criminal offense will appear. That is the primary purpose of bail, is securing someone's appearance. So how can you secure those appearances? Well, there are appearance bonds, which is a written agreement to pay a certain amount if someone fails to appear. There are secured appearance bonds, which are that written agreement plus a portion, usually about 10% being paid in advance. There's a surety, which is someone who is responsible and pledges to be responsible for someone's appearance. And it could also be someone who's charged with being responsible for someone's conditions and that person being compliant with them. There's a surety bond, which is a written agreement under which a surety guarantees that appearance and pledges to pay the court for a specified amount if the person fails to appear. So these are all different ways to secure that person's appearance. And then there's this term that's going to become very familiar called flight from prosecution, which again is part of the main purpose of bail, is to make sure people don't flee. And that's any action or behavior undertaken by a person charged with a criminal offense to avoid court proceedings. So any questions at the outset about just sort of these working definitions as we enter into the nitty-gritty? Okay. So generally speaking, pretrial release is founded in the notion of people are innocent until proven guilty. A foundational concept in American and Vermont society. It's grounded in both the U.S. and Vermont constitutions and detailed in statutes. So it's the U.S. Constitutional Amendment. It's the 8th Amendment. It's in Chapter 2, Section 40 of the Vermont Constitution. And these concepts are embodied in Chapter 229 of Title 13, which are bail and recognizances. So those are that houses a lot of the statutes. And again, so constitutionally legitimate purpose of bail is to ensure a person's appearance in court. You will hear that refrain many times in this presentation because it's so important.
I have a question. Is it the US Constitution or the Vermont Constitution or both that prohibits people from being held in a carceral institution due to a debt?
I know the Vermont Constitution has that explicit. I'd have to double check it was the US or
Okay. Yeah.
Bail can't be used to punish the defendant or to protect the public, but conditions of release can be a mechanism that's used as a form of public protection. So these are the general operating principles, and we're going to get into the details that underlie each one. So constitutional requirements. Again, this is going to be the text of Section 40 in Chapter 2. So I'll kind of briefly go over it, but this is sort of the threshold requirement, excessive bail shall not be exacted for bailable offenses. So bail can't be excessive, but there's also a case law that says it doesn't have to be affordable either. So where that falls in between is up to judicial discretion based on the facts and circumstances of the case. But you'll see that all persons shall be bailable by sufficient security. So that's the key phrase. Everyone's subject to bail. Except,
But that doesn't have to be cash bail, correct?
well, so even though bail is defined as cash, people can be released on their own recognizance. Or they can just have conditions imposed without monetary bail imposed as well. So one, if someone's accused of an offense with a possibility of life imprisonment, this says death, but the death penalty no longer exists in Vermont, so that's not really a factor. But they may be held without bail when the evidence is great. There's also the violent felony exception. A person accused of a felony, an element of which involves an act of violence, may be held without bail when evidence of guilt is great. There's clear and convincing evidence that the person's release poses substantial threat to physical violence, and that no condition or combination of conditions will reasonably prevent that physical violence. You're going to remember this from a bill last year where we discussed the evidentiary standard in these violent felony hold without bail proceedings. And so now, after that law passed, it's the evidentiary standard is the same as the life imprisonment one. So the rules of evidence don't apply. You just have to show that evidence exists, but not that but you don't actually have to admit it. And then finally, a person awaiting sentence or a sentence. We're not going to really be talking about that here because this is sort of post-trial. And then everyone's entitled to review within 7 days by a panel, a 3-judge panel, justice panel of the Supreme Court if bail is denied. And then for the violent felony exception, there's a 60-day trial requirement. So if someone is denied bail and they're held, trial has to be scheduled within 60 days of that denial. And if the defendant doesn't waive that time and the trial isn't held, or waive that privilege essentially, or that right, then after that 60 days pass, a bail hearing is scheduled and conditions will be set.
Are there any constitutional provisions for someone who has been offered bail, can't pay that bail, and is now just stuck in a facility because, okay.
And then finally, no person shall be in prison for debt.
Hey, look at that.
There you go.
I should have read ahead.
So what are the statutory foundations of these constitutional principles? So in 13 VSA 7554 is what prosecutors will refer to as their Bible when it comes to bail. This is where everything lives. And so you'll see any person charged with an offense, other than those exceptions that we talked about, must at his or her initial appearance be ordered release pending trial. So again, the presumption is release. And then further down in the statute, the defendant shall be ordered release upon personal recognizance or upon the execution of an unsecured appearance bond in an amount specified by the judge, unless the judge determines that release will not reasonably mitigate the risk of flight for the prosecution as required. And then there's a whole analysis that the court can get into to analyze risk of flight related to bail, and then also a secondary analysis for conditions related to public safety, which we will get into. So what's the scope and limitations of bail? Again, bail may only be used to assure the defendant's appearance in court. It can't be used as punishment or to protect the public. The statutes themselves create a presumption in favor of pretrial release, where courts are required to impose the least restrictive condition or combinations of conditions, unless there's a flight risk that's determined.
And can I want to ask a question. I'm looking at State versus Pratt, where the Supreme Court says that bail cannot be used to protect the public. If hypothetically we were to pass a law that says actually bail can be used to protect the public, can you describe what you think might happen?
Well, this is all speculation and, you know, we don't like to speculate, but if that law were to pass and someone was ordered to be held for public protection or whatever, chances are their attorney would file a lawsuit. And then presumably it would make its way to the Supreme Court and the Supreme Court would issue a ruling. But since the Constitution does not allow it, not having a crystal ball, I would presume that it would be deemed unconstitutional. So really a constitutional change would have to occur in order to change that paradigm.
Thank you.
So bail and other appearance bonds can't be imposed. At the initial appearance for misdemeanors, if someone's just merely cited and not arrested for the offense. So if I were to, Senator Matos, if I were to arrest you and I cited you, typically that citation says, okay, I'm not gonna hold you, but you have to appear in a couple weeks at this date and time. So, nothing's gonna be imposed in that circumstance, at least as far as cash. But at that initial appearance, for expungible misdemeanors, so ones that are eligible to be expunged, bail or those securities can't be imposed unless the court determines that bail is necessary to mitigate that flight from prosecution. And in that case, if that's determined, there's a $200 cap on the amount that can be levied. But as a result of S-195 last year, that cap would now be removed if someone is already on pretrial release for one of those qualifying misdemeanors and is brought in again. So that $200 cap wouldn't be in play at that point.
I'm just trying to understand the sort of interplay here. So if someone is brought in again for another crime, this applies. If someone is brought in simply because they say one of their conditions of release was don't drink alcohol and they had a beer, would this condition also apply in that instance, even though having a beer isn't a crime in and of itself? Does my question make sense?
Well, yeah, so it would have to be a new crime.
Okay, so it can't just
So
be
it wouldn't be a violation of conditions, but sometimes violations of conditions are considered a crime.
even if the underlying violation isn't a crime?
Yes,
And in that instance, it would apply,
it depends on what the order is.
but it could.
It could.
Okay, thank you.
If I could give an example, I think, you know, if there's a condition that says stay 300 feet away from such and such person, and then the defendant is charged with stalking that person, they're within 300 feet, which is a violation of condition,
Right.
also a crime.
Yeah.
It would also violate the other condition, which is you shall not commit any other crime, so it's 2 VCRs at least.
Yeah, and then that's the other thing. There's the violation of conditions really that is its own separate criminal offense that can be charged as well.
Well, right, and that's what I'm trying to understand is like, in your example, stalking is a crime, whether you're on conditions or not.
Right.
But if someone is ordered not to drink and they have a beer, that's not a crime in and of
That's true.
itself.
So I was misunderstanding your question. I'm sorry. Yeah, so it wouldn't necessarily qualify in that circumstance.
Okay,
But it would be if you committed a new crime that was also a violation of conditions after you get into that kind of.
right, and I was trying to understand the sort of nuance between the violations that aren't actually in and of themselves crimes.
Yeah, sorry about that.
No, no worries.
If I might, using that example, I mean, we've heard from the Defender General's office where the problem is that once you've been charged with a crime, we're getting a backlog of cases here because all these violations of conditions released are being charged against, such as a curfew, for instance. That's going to be a crime in itself. And under general circumstances,
Well,
a lot of them won't be crimes, but when they get charged with a citation.
when they get charged as a violation of conditions, so as a, yes. But what the other possibility too is that if you violate conditions, you can be brought back into court and just have another bail hearing to reassess those conditions. So that's something else that takes up court time. So it's not necessarily a new charge, but it's court time to say, okay, what's going on? Why are you violating conditions? Do we need a new set of conditions so that you really follow them? So there is that time consuming process as well.
Never done that, but must be an option.
It is. Okay. And so moving on, Those constitutional exceptions are governed by 13 VSA 7553 and 7553A, which we're going to get into now. So there's those three constitutional exceptions that we went through: life imprisonment, violent felony, awaiting sentencing. 13 VSA 7553 governs holding someone without bail for a crime subject to life imprisonment. So the crime charge has to have that maximum sentence, and the evidence of guilt needs to be great. There is a presumption of detention in the statute. So that's the presumption, is that when you're charged with that crime and there's a motion to hold you without bail under this statute, you need to rebut that presumption to stay out of jail. And then if the evidence is not great, so there isn't a body of evidence that exists that doesn't necessarily have to be admitted, but that presumption is overcome, then there's a bail hearing set, probably right away, where you would then release the person subject to conditions and whatever is appropriate given the case. So that's kind of the quick and dirty for hold without bail for life imprisonment.
Ben, can I just add some maybe helpful historical context? This is something that, there was a big change in the 80s, and prior to that, people could be held pre-trial only if they were about to face execution, because the impetus for flight is high when you're facing death. And
Yes.
most people are going to choose to run away, most likely. And since we don't have the death penalty, life imprisonment is the second worst thing that can happen to a person. So that's part of the context as to why we had this and why it continues.
Yeah. So, and to piggyback off that a little bit, that came about through a constitutional amendment. Because as you alluded to, Mr. Chair, that before it was just when you're facing execution. So in the 80s, there was a constitutional amendment passed, and I actually remember
Senator Bloomer?
Yeah,
Yeah.
the elder
Yeah.
Senator Bloomer. But it was from the late great Senator Sears regaling us with the story that he, I think, was maybe a freshman legislator when an issue went before the Supreme Court, and they were trying to determine the scope of holding someone for public safety. And Senator Bloomer Sr. rushed over to the Supreme Court because he heard that they were interpreting it in a more restrictive way than the legislature had passed it. And ultimately, that's what prevailed, was that more restrictive view for these two exceptions. And I wasn't there, obviously, but I believe the conventional wisdom was to get at public safety as a whole. But here we are. Sure, Secretary Bloomer Jr. May have some stories about that as well. Yes. So moving on to the violent felony, this was a bill that was sponsored by the chair last year to change the evidentiary standard. So you have to be charged with a felony. It has to contain an element of violence. Evidence of the guilt is great, just like the life imprisonment statute. And then clear and convincing evidence shows that release poses a substantial threat of physical violence to any person. No condition or combination conditions can mitigate that physical violence. So clear and convincing evidence, as a reminder, there are really three levels of evidentiary burdens in criminal law. There's preponderance of the evidence, which is 51% more likely than not. Clear and convincing, which my professor said was somewhere within 70 to 80% maybe, and it's really where it's almost a certainty. And then there's beyond a reasonable doubt, which is there really is no doubt, greater than 90, 95%. And so this is that middle ground here. And hearing the testimony from last year, the reason why that's the standard is because they don't want to hold full-blown trials at this stage. But you need to have really good evidence if you're going to hold someone before they've been adjudicated guilty.
Just to clarify, I believe the change was to clarify that the rules of evidence
Don't
don't
apply.
apply. Yeah.
Correct.
And the clear and convincing standard remain the same.
Yes, that is correct.
Just
So,
wanted to.
but you still need evidence. You just don't have to go through the rigors of introducing evidence by having witnesses that you've introduced statements through, you could just introduce a signed affidavit. But the clear and convincing evidentiary standard still didn't change as you stated, Mr. Chair. So you still have to have a good amount of evidence to hold somebody. And again, if they are held, that speedy trial requirement kicks in, needs to be held within 60 days. And then if not, real hearing is set. Any questions on those two statutes? So risk of flight. Court determines this in various ways, but first, in addition to any other factors, so the court has the discretion to consider anything that's relevant and that's available to them. So information that's presented by either the defense or the prosecution. Number one and number two were present prior to last year's legislation. So the seriousness of the offense, the number of offenses with which the defendant is charged, those were always the primary factors. And now, because of S-195, they added the bottom three. Whether someone's been released pending trial for another offense, if they're under DOC or federal supervision, so that would typically be post-trial, and what their record is when it comes to compliance with court orders and appearances related to a criminal prosecution. There was testimony last year that said many courts across the state consider these factors, but the legislature decided to memorialize them in statute. So really for the avoidance of doubt, that if you're in court in Bennington or in court in Orleans, the judges are all considering the same things. If the court determines that the person's a risk of flight, it then crafts those conditions that need to be the least restrictive. And that's on the basis of the available information, nature and circumstances of the crime, the weight of the evidence. So how much support do you have to prove those, the offense? Is someone employed here? Do they have ties to the community? What are their financial means, including their ability to post bail? What's their character and mental state? How long have they resided here? If they're transit, they've only been here for a long time, they might have a condition imposed that you can't leave the state. Maybe that's less of a concern for someone that was born and raised here. And what their essentially their criminal record is. See if they have a record of non-appearance and things like that. So those are what the court uses to impose the conditions. So what are the conditions? So there are conditions that can be imposed strictly related to bail. So to keep people within jurisdiction so they don't flee. You can place a defendant in the custody of somebody or an organization. So basically, like for instance, my anecdotal example is it was my first bail hearing ever as a practitioner. And there was this guy charged with a slew of charges, and he couldn't make bail. So they were going to put him in jail. But his dad decided to be his designated person that would be responsible for him and be responsible to report any violations of conditions, any new crimes that are committed, so on and so forth. So that's an example of somebody that could be assigned, but they are pledging in a written agreement to be that person, and they can get in trouble if they don't follow that commitment. You can also place restrictions on travel or association.
Just real quick. So if somebody does that in your example and middle of the night, guy's son cruises off, leaves the state, what does that mean for that designated person's father?
Well, he'd have to report that.
So he reports it just like he should.
Yep.
Does he get in trouble because he lost him in the middle of the night, or
They can get,
They can.
can't
It's discretionary.
if there's like reasonable care that
Yeah, it depends on what the outline of the responsibilities are. Now, if he didn't report,
Then he can
then there's really discretion. But yeah, it kind of depends.
case by case basis
Yeah.
usually. Okay. Cool.
So you can place restrictions on travel or association. So, you can't go to a certain place at certain times. You can't have contact with certain individuals. You can require participation in alcohol or drug screening. This also considers the availability of those resources. So The court tries not to order things that can't be followed through on. Then again, you can impose a financial component not to exceed 10% of the bond amount, but again, the court considers the financial means of the defendant and the deposit is returned if the defendant follows through. Again, you can require execution of a surety bond and any other condition reasonably necessary to mitigate the risk of flight. So it's sort of the catch-all provision, if you will. There can be no contact provision with victims. So if there's a domestic assault case, you can say boyfriend X, you can't have contact with girlfriend Y. And these are new additions last year from S195. You can now place people in home detention or in a pretrial supervision program. And I'll get into the details of those programs in a little bit. Then there are public protection conditions of release. So after the court does that bail assessment. Yes.
I have an update or a question around bail and if there's an update about the effectiveness. I know last year we had some data, I think it was from 2018 to 2022, that it actually showed that bail has no statistically significant impact in making people more likely to return. And I'm wondering if there's any updated information. Okay. Now I'm trying to remember who gave us that data.
It might. Yeah, I don't know. I couldn't say. I know the Department of Corrections has a lot of data on specific numbers, but maybe not about that trend.
Okay.
So after you get through that initial bail analysis, if those conditions are deemed to be insufficient for public protection, then you can do a secondary analysis for public protection and attach attach conditions of release related to that concept. So they're very similar. In the analysis and in the conditions that can be imposed. So as I just said, insufficient, then you do this analysis based on the available information, really similar considerations as the bail considerations as well. I'm going to try to speed it up because I know that we're butting up against time.
If you, like I said at the beginning, I think this is going to be one of the most important presentations. So if we get to 11:25 and we still need more time, I'm happy to have you come back in tomorrow or next week. So
hopefully I don't take another 25 minutes. But very similar factors that are considered by the court in this analysis. And then the conditions themselves are very similar. There's one different condition when it comes to the suspension of a law enforcement officer's duties. So if someone is charged with embezzlement in their official capacity, a condition could be to suspend that law enforcement officer's duties, and if it's necessary to protect the public. So
then
it looked like your wheels were going.
Wheels were going a little bit. I wanted to just get some information out there regarding these lists of what can be taken into account regarding conditions of release related to bail. And these factors stem from the precedent that we can't just put anybody in jail. And these are precedent established by the Supreme Court, both Vermont and the US. Is that correct?
As far as the specific conditions?
Not the specific conditions per se, but the fact that it has to be narrow. The fact that it has to be narrow and that it can't just be, somebody drinking a beer and they violated their conditions. And they were conditions of release for a disorderly conduct when they were drunk previously. Doesn't rise to the level that's been established by courts. As to when you can send somebody back to jail.
Right, and that's really enshrined in the Vermont Constitution to a degree, the federal Constitution. But yeah, it goes back to that primary legitimate purpose of bail is to secure appearance, not public protection. And also in our statutes that it's the least restrictive condition. So, for someone that just breaks their condition by drinking a beer, well, okay, all of a sudden we can't just say, oh, you might endanger someone because maybe you'll get in your car and drive if it's from a disorderly conduct charge. So you can't go all the way to, we're going to throw you in prison now. you have to find that least restrictive condition to ensure A, their appearance in court, and then B, to protect the public. So does
And
that answer your question?
it does, and the least restrictive, the idea of these conditions being the least restrictive, is that just some unique Vermont idea, or is that also tied to precedent that's been established?
It's more Vermont.
Senator Middleton.
So I have two questions. One is sort of in this line of questioning, and so let's go back to our friend who got a disorderly and then had a beer. No, we can't just throw them in prison, but could we give them $500 in bail, which effectively keeps them because they don't have it?
Potentially. Again, it's a possibility, but it all depends on the facts of the case.
And judicial discretion.
Right.
Okay. So my next question is around this law enforcement, this piece around suspending law enforcement officers' duties. Is it only if they're charged with violating this embezzlement in office?
Mhm.
So if
And
a
it's
law enforcement
necessary-
officer assaulted someone, they could not have their duties suspended to protect the public.
Yeah, it's only this embezzlement statute.
Where is that?
It's
The
right
third from the bottom.
here. It's interesting to me that,
But
Yeah.
not domestic, well,
right, not domestic violence, not assault, just embezzlement.
Something may have, like most laws are on the books because
Yeah.
there's an impetus for them. So not knowing, but I'm assuming that there was an incident like this, which is why it became a condition of release.
Yes, well, I'm now recognizing there's some incidences of the other amendment things.
Any other questions on this slide?
doesn't look like it.
Okay. So let's get into home detention because this was a program that was expanded last year in S-195. So in general, home detention is a program of confinement and supervision that restricts someone to a pre-approved residence continuously, except for pre-approved absences for work, school, medical appointments, things like that. So to think of it, it's probably one of the most, if not the most serious condition you can have imposed next to being in prison. Because essentially, this pre-approved residence is your prison. You're just not incarcerated in the traditional sense. This is governed by Title 13, Section 7554B. There are now two different bases for home detention as a result of S-195. Prior to that, there was just one for inability to pay bail. This would be an option for those people, and I'll get into the details of that. But last year, it was also added to cover those who violated conditions of release. And then in both circumstances, if someone is ultimately adjudicated guilty and imprisoned, the time they serve in home detention can be used as credit for time served in prison. So let's talk about inability to pay bail. Chair Election Senator Bielski.
That is also true. So the home detention can count towards a sentence. That would also be true of pre-trial detention in a jail, yes.
It's not an explicit.
Not that
transfer.
it has to be, but it could be.
I think, I think it's an option, but I can't say for sure.
Yeah, I was just trying to understand if we were treating home detention differently, because to your point, that has become your jail. I was just trying to understand if we were treating it differently than detention in a carceral.
I mean, it is treated differently in the sense that it's an explicit grant of
Okay,
credit for time served.
got it.
But I don't know the question, the answer to the other part of your question. So inability to pay bail, this was the pre-existing program, which was if someone who was detained because they couldn't post bail. So they said, okay, you can be released, pay $100, you're good to go. They couldn't afford the $100. So then they're detained. If they were detained for 7 days or more, or for more than 7 days rather, the court or DOC or the defendant can make a motion to say, I don't want to be in jail. I'm an appropriate placement for home detention. Let's explore that option. So the way the process goes is that once that motion is made, DOC does an assessment of the proposed residence for the use of electronic monitoring, because that is part of the home detention program, that ankle bracelet. And essentially, if you have cell service at your house, the house is most likely going to be approved at least for that electric monitoring because it's tied to cell service. But as we all know, that's an issue in the state like Vermont because cell service can be spotty. So what that will inform whether or not someone can be placed in the program. Other factors, though, that the court considers is, there's the edit issue. I have it there twice. But in determining whether someone is appropriate for home detention, separate and apart from the residence being suitable, is they look at the nature of the offense charged. They look at their criminal history, prior history of violence, medical, mental health needs, history of supervision, risk of flight, and any risk or undue burden to other persons residing at the proposed residence, risk to third parties, or risk to public safety. So for instance, in that domestic assault example I gave, if the boyfriend and girlfriend are living together, probably not going to be placed in home detention because you'd be confined with the victim. And then DOC, since you would otherwise be incarcerated, but for this program, has the ability to revoke your home detention for any unauthorized absence or failure to comply with the condition of the program. And then they would be returned to incarceration.
Senator Norris.
And out of that particular instance, I thought we had discussed that DOC America's probation pro don't have that without judicial review.
They have that. There's more process in the second part of the program
Okay.
that was established last year,
Okay.
and this wasn't changed last year. This portion of the program.
Senator Bowles.
So two questions. Once with the clarifying question around cell service, does that mean that the individual has to themselves have a cell phone or that they have to be able to get service?
They have to be able to get service at the home.
Okay. And then my other question is around, so it's a defendant who's been detained at a correctional facility for more than 7 days for lack of bail may be reviewed. It's not shall be.
Right.
So it's
Because
entirely
it's only upon a motion. So the defendant, DOC, or the court would have to make a motion to say, let's examine home detention.
But if the defendant makes that motion, it shall be heard by the court.
Well, any motion would be heard.
Yeah.
That the discretion is what, you're not required to submit the motion.
Yeah. Just want to make sure that it's clear that, like if a defendant files a motion to have their bail reviewed, it will be heard
Okay.
within, should know this,
It's
2 weeks.
It's normally a couple weeks, yeah, because at that point, that starts the clock for the assessment the DOC does. They submit that report. Once the report is submitted, it's then scheduled.
Yeah.
No, so I'm just, so this is a defendant who is there because they can't pay bail. If they were a wealthier person, they would be out entirely. And the only option for them is be incarcerated because you can't pay bail or be incarcerated at your home because you can't pay bail.
In this program, if they were to make a motion for it, yes.
Is there another motion that can be made to address the lack of ability to pay bail?
I mean, I think the defendant could probably make that argument in court that bail is too excessive, which is a constitutional argument. But again, bail, while it can't be excessive, it doesn't have to be affordable. So, and that's part of the carrot and stick approach, right? It's to say that we want to make sure that it's a serious enough amount that you're going to actually appear. So is that an affordable amount? Maybe, maybe not. Again, it's up to the facts and circumstances of the case and the judge's discretion.
Also, home detention can be used for individuals who are having their bail reviewed in an attempt to get released, either 7553 and 7553A.
No. Because in that statute, it says it's not an option, or it's in the home detention statute, it says it's not an option for those hold without bail situations. Now, this new second program is for violations of conditions. So someone who's allegedly violated conditions can be placed in home detention if they're deemed a significant risk of public safety, placement will mitigate the risk, and the residence is appropriate. So it's a similar procedure to what we just went over. But there are some differences concerning compliance and remedies for non-compliance. So DOC has discretion to report violations of home detention. It's not required. They make the decision themselves. But they can't report violations that are the fault of the defendant. So for instance, you have to keep these ankle bracelets charged, right? If for some reason the battery just goes kaput, that's not really the fault of the defendant. So they're not going to be, so their home detention is not going to be revoked for that situation. But if there are reported violations, prosecutors have a few options. They could just ask for a review of conditions. So what I said before, that bail review hearing, just to reassess, be like, do we need a different set of conditions? Do we need higher bail? But, at this point, home detention is probably one of the more serious conditions you're going to have. So it's an option, but, I'll leave it to you to figure out how effective or what different combinations it could be. They can hold someone in criminal contempt, which is its own separate criminal charge. So it's also that violation of conditions charge that I talked about. I believe it's 13 VSA 7559. It's a separate charge, carries its own penalties. So that's another option. And then bail revocation, which from my understanding and the testimony is sparingly used because it's such a high bar. You really need a legitimate and compelling interest to hold someone or to revoke their bail and hold them. And I'll get into that a little bit later, what those considerations are. Bail revocation.
Right now.
So under section 7575, there are a few circumstances that bail can be revoked. If you've intimidated, harassed a victim, potential witness, juror, or judge in violation of the condition of release. If there are repeated violations in a manner that impedes the accused, but single violations alone are insufficient. There's a state v. Sauve, we've talked about the exact pronunciation of which I'm unsure, but there must be a nexus between those repeated violations and a disruption of the prosecution. So what does that really mean? Well, what it would mean is something similar to what the threat to the integrity of the judicial system. So if you're disrupting the prosecution, you're probably trying to destroy evidence, maybe harassing witnesses, things that would really make it hard to bring the case to trial and hold you accountable. But repeated violations of conditions alone, they're an inconvenience, but they're not really a disruption to the prosecution. So they're largely insufficient.
And just for some additional context, this State versus Save cases was a case where the defendant was charged with a domestic conditions of release, then he was charged with a DUI violations of his conditions of release, and then an unlawful trespass against the victim from the domestic, another BCR, and then another unlawful trespass, which was also another BCR, still not held. And the Supreme Court found that there was no nexus between impeding the prosecution and impeding the prosecution in such a way that that they could revoke bail. And so that's a Supreme Court decision.
Yeah. And you'll notice a difference between the court decision, which talks about disruption, and then the statutory basis, which classifies it as impedes or impediment. There's probably an academic discussion between what's the difference between a disruption and impediment. Impediment presumes that there might be something blocking the start of a prosecution. It impedes it altogether. Disruption is like a blip in the course of it. So it's an interesting dichotomy or difference between what the statute, the level that the statute reads versus what may be a little bit of a lower bar per the constitutional requirement. But Senator Sheen, to your point, it's still a really high bar to meet. And then there are two other bases, without just cause, fail to appear in specified time and place in front of the judge. But again, not all these have been litigated yet. Probably would still need that nexus. And in a violation, you can charge with a felony or a crime against a person or anything similar to the underlying charge. And again, hasn't really been litigated, but presuming it would need a high bar as well. So in summary, what does this all mean? Everyone is subject to bail as of right, unless one of those three constitutional exceptions apply. Bail amounts cannot be excessive, but do not need to be affordable. It's presumed that everyone subject to bail must be released on personal recognizance or a bond unless the release will not reasonably mitigate that flight from prosecution. Conditions of release can be tied to both bail and public protection and crafted in least restrictive ways. And then the right to bail can be revoked only in legitimate and compelling circumstances, as we discussed.
Regarding compelling circumstances, can you provide a little more context as to what a compelling state interest is?
I mean, honestly, it's really based on those few cases. That would be disruption of the prosecution. It would be hard for me to elaborate otherwise. I mean, I think that you could probably imagine some compelling situations, and since those not every basis of bail revocation has been challenged in court, maybe there'll be a divergence if there was a challenge based on one of those different bases, but I'm not going to speculate.
Is there a legal definition of excessive?
Yeah, I think in the Supreme Court cases there is, but I don't have it at the ready. But
That's state versus Pratt.
I think it is. Yeah. So yeah, I'm sorry, I don't have that information now, but I can get it for you.
Thank you.
Sure. I don't even need to be here.
Mitty, any questions, thoughts?
Not at this point. As usual. An exceptional job.
Well, I could have done without Mr. Chair.
I'd like to say that.
Hold that.
And you know what? Only 20 minutes, not 25.
Yeah, it's good.
In spite of my long-windedness. So happy to answer any other questions you may have, of which I have the answer at the ready, which does not include excessive bail definition, but,
Yeah, no, it's good. This, I mean, gives us the primer for inevitable conversations we're going to have about some of the proposals we've received from the administration, which involve, for instance, talking about changing the word impedes and replacing it with the word disrupts. So that's just one example, but yeah, just some good context for how we're going to proceed when we begin those conversations.
and please feel free to hold on to this, use this as a resource throughout the session. If you read it and be like, what was Ben talking about here? Shoot me an email. I'll answer any questions you have.
Thanks for coming in. Appreciate it.